The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to this sitting of the Massachusetts Appeals Court. The panel this morning are Justices myself, Justice Wolohojian, with me are Justices Sullivan and Justice Ditkoff. We'll be hearing one case this morning. It is case number 2020P 1085, Catherine Brauner versus ALEXANDRA GOLDEN and others. And counsel, the case is partially impounded, so please keep that in mind and don't refer to by name to whatever is the impounded material or explicitly to whatever is the impounded material. And with that, Attorney Fryer, we are ready whenever you are ready to begin your argument.
Thank you, Your Honor. May it please the court. First, I'd like to thank the panel for accommodating my request to conduct the oral argument via Zoom. I appreciate that. First thing I'd like to address is a really critical issue concerning the matter of the at-issue waiver, and that is that the lower court misapprehended the nature of the case. The premise of the lower court ruling was that this is a case alleging malpractice. And the court repeatedly characterizes the claims as alleging malpractice by Attorney Allen. But this is not a legal malpractice case. The plaintiff's claims are not based on any attorney-client relationship they had with Attorney Allen. They were beneficiaries of their mother's trust. He was the trustee of that trust, and he was the personal representative of her estate. But none of the conduct misconduct that's been alleged was in any capacity that Attorney Allen was acting as attorney for either plaintiff. So that means, and the court also referred to successor.
Why would that make a difference when one of the claims is a breach of fiduciary duty claim?
The reason it matters, Your Honor.
It seems to me very close, at least conceptually, for these purposes, to legal malpractice claim.
The reason it matters, Your Honor, is because the case that the court relied on, the principal case, the Zabin case, is a case involving successor representation by counsel, where you had multiple counsel involved. And the whole premise of the court's rationale here is that Allen was former counsel, that the attorneys' communications who are at issue here were successor counsel, and that under the logic of Zabin, therefore, there is an at-issue waiver, and that doesn't apply. If Attorney Allen had not been an attorney, if he had simply been a layman acting as trustee and personal representative, I don't think we'd be here. Because it would be obvious that there was no successor counsel, and Zabin would have no application.
Well, can you help explain the count 2, the negligence claim, where in paragraph 33 of the second amended complaint, you allege that the decedent, you call him in the complaint, but the attorney owed a duty of care to Mrs. Brauner and to the plaintiffs?
Yes.
What is the relationship that you're relying on? I assumed it was the attorney-client relationship with Mrs. Brauner.
Well, two things. One is that the plaintiffs were intended or obvious beneficiaries of the estate planning that Attorney Allen did for the plaintiff's mother. But also it's because they are beneficiaries of the trust, and he had a duty, had two duties. One is to not act negligently, and the other was to not breach his fiduciary duty to them.
Sure, but in count 2, you have this negligence claim where you allege that he owed a duty of care to Mrs. Brauner. Was that the duty of care that arises from an attorney-client relationship?
No, that none of these claims, if you read the factual allegations, there are no allegations that Attorney Allen was ever acting as attorney for the plaintiffs as his clients.
Okay, so then why does that matter? Why does it even matter? Are you, because are you, I guess what you're arguing is that you can't have an at-issue waiver of the attorney-client privilege unless you're asserting a legal malpractice claim?
Well, I don't know if that's the case or not. That's certainly not our case. The available case law involves predecessor and successor counsel. The Zabin case and the Petro case both involve situations where the plaintiff was suing his former counsel, and the question was whether his communications with his successor counsel could be discovered because of an ad-issue waiver. And the point of the logic of it is that there's an ad-issue waiver because, if there is one, is because the actions of the former counsel as counsel have been implicated. And so that logic simply does not apply where there's no attorney-client relationship between Attorney Allen and the plaintiffs.
But that's what my question, maybe you've answered my question. I'm trying to see if what your argument essentially is that unless there's an attorney-client relationship, there can never be an at-issue waiver of the attorney-client privilege.
Well, I think that's the case, Your Honor. If we had a situation here where Attorney Allen wasn't an attorney, he was simply a layman trustee, then the whole Zabin logic wouldn't have any relation.
Okay, but that still may not make the lower court's ruling wrong, because it seems to me the issue is whether you were entitled to both simultaneously rely on the discovery rule and assert the attorney-client privilege.
Yes, that's what the Darius case says. The Darius case very specifically says that this is a case where the plaintiffs did not raise this issue. It was raised by the statute of limitations defense asserted by the defendant. And Darius specifically holds that where the defendant asserts a statute of limitations defense and the plaintiffs then invoke the discovery rule, that does not create an ad-issue waiver. That's quite clear. And although the court does suggest that there might be circumstances where an ad-issue waiver in that kind of situation could occur, no case in Massachusetts has ever held that to have happened. Furthermore,
what happens here when, for example, I read the plaintiff's interrogatory responses, and they essentially gave no substantive answer to the question of when and how they learned of their claims.
Well, what they've said is that they learned of the claims when they first consulted with their present counsel.
Can you point me to the page where they say that?
I'm sorry, I don't know whether that's in the answers to interrogatories or in the deposition
Right.
testimony, but I know it's in the record. I can follow up with the court later if you wish me to give you the site. But that's the whole point. If they had never come to any other attorney before coming to present counsel, and we had this situation of statute of limitations defense and claim of discovery rule, then under Darius, there would be no waiver, and there's nothing about the circumstances that change that.
But they're not seeking a waiver of the communications with you, with their present counsel. So if we looked at the analogy you just posited,
Yes.
if they had not consulted with any previous counsel, then there would be no issue of attorney-client privilege communications. The defendants would be entitled to explore everything that might bear on when the plaintiffs may have discovered they had a claim, right?
Correct.
And there would have been no issue of privilege until they got to retaining you, however many years later. But here, they apparently contacted and perhaps even retained many counsel before they got to you.
Your Honor, let me clarify one thing in the record. The lower court said it was undisputed that the plaintiffs had consulted with more than 20 attorneys before coming to present counsel. If you look at the privilege log information, you will see that 15 of those consultations had nothing to do with the claims against Attorney Allen. They had to do with a potential lender liability claim involving one of the plaintiff's home in Harwichport. So, those numbers are wildly inflated. The fact that they went to a few attorneys before they retained present counsel in order to consider the possibility of a claim does not waive the privilege. There simply is no waiver of the privilege.
I don't think anyone's claiming that the fact that they consulted lots of people waived the privilege.
And the fact that yeah, go ahead. I'm sorry.
What I was trying to get at in my question was, if they had not retained any counsel or consulted with counsel, it seems to me the defendants would be entitled to full discovery of everything that led up to their retention of you in order to test the claim of the discovery rule.
I agree.
Right?
Yes.
So if they, in the process of everything else they did, consulted with lawyers during that same period, how is it when they rely on the discovery rule that that's not also discoverable, that if it bears on their assertion of the discovery rule?
Your Honor, the logic of the attorney-client privilege is that those communications, whatever they were, are protected. And the whole point of Darius is that you can't get at such communications simply by asserting a statute of limitations defense.
Right. So one solution, for example, might be to protect the attorney-client privilege by saying you can't reach the communications, but not allow the plaintiffs to rely on the discovery rule, or to deem the dates of those communications to indicate discovery. What would be wrong with that?
Well, first of all, there's no authority under Massachusetts case law supporting such an approach. And the problem with that is that effectively eviscerates the attorney-client privilege. If you review the discussion in my brief about the logic behind the privilege and why, because of its importance, it overrides this kind of concern, to rule the way you were suggesting would be to mean that the privilege is not absolute, that the privilege is qualified, and that you have no idea exactly when it's going to be protected and when it's not. And the whole point, the whole logic of the attorney-client privilege is to have the client have the confidence to, as you know, to discuss every aspect of the situation with their counsel, knowing that those communications are privileged.
Your privilege log was not the most detailed privilege log I've ever seen. Do you think that one solution here is to remand and for the judge to view the documents on the privilege log in camera?
Your Honor, I have 2 points. One is that the lower court judge, specifically said that the privilege log was adequate. And secondly, the privilege log contains exactly what defense counsel requested be specified in the privilege log. So I don't think the defendant has any right to claim now that the privilege log is inadequate when it contains exactly what he specified that it should contain. As I argued in my brief, there's both under waiver and estoppel doctrines. If he thought the privilege log was inadequate, he should have moved under Rule 26 to require a more detailed log. And he shouldn't be allowed to complain now that the privilege log is inadequate. It has exactly what he asked for, and the lower court found it to be adequate. I understand that it may not be the most detailed privilege log ever, but it took a lot of time to prepare the log as it is, and it was done in reliance on what defense counsel said would be considered adequate. Certainly, if the court doesn't accept that, a remand would be preferable to affirming the decision for that reason. But I don't think it's appropriate to remand when everyone to this point has proceeded on the ground that the privilege log is sufficient and adequate. So the other thing I'd like to address primarily is the common interest issue. The court relied on comment D to the restatement provision as support for the lower court's position that the common interest doctrine does not apply to one plaintiff communicating an attorney-client communication to a fellow plaintiff who is not also represented by counsel. The SJC has not, I see my time has expired. Can I just finish this point, if I may?
Yes.
The SJC has not endorsed comment D. Then the discussion that they had in the relevant case.
Counselor, why should it apply in that situation? You have one person talking, one non-lawyer talking to another lawyer and disclosing what their attorney said to them, what they said to their attorney. That seems like just a normal waiver situation.
Because the whole logic of the common interest doctrine, as I discussed at some length in my brief, is that it does extend that the SJC has said that the common interest doctrine should be applied expansively. And all of its discussion in the relevant case suggests that it cites favorably cases from other jurisdictions where it did apply in this kind of situation. And so there's every reason to think that the SJC would say that it applies here as well. And so I think absent any further indication from the SJC to the contrary, that the common interest doctrine should be applied expansively. There's no reason why the plaintiff, Catherine Browner, did retain counsel shortly after these discussions, these communications sharing the privileged information. And to say that, and one could reasonably infer that she did so based on what her sister had told her. So to say that if they had had these communications just a few months later after she had retained counsel, and that would be protected, but it's not protected here, where they obviously had common interests in the representation that Susan had undertaken, doesn't make any sense to me.
I take it that there was not a separate log produced for each sister?
No, it was all a single log.
And are there any documents on the privilege log that Catherine herself has an attorney-client privilege to, as opposed to via an assertion of common interest?
I don't recall, Your Honor. I'm sorry. Yes, I believe there are. I can't. I'm not absolutely.
How would one know that from the log?
I'd have to look at the log to refresh my memory, Your Honor. I do believe there are communications. I'm almost certain there are communications from Catherine to counsel, but I don't want to represent absolutely that's the case without double checking.
Let me see if any panel has any further questions. No, thank you. Thank you very much.
Thank you.
You probably want to put yourself on mute when we turn to the other argument. Thanks. Attorney Wiegand.
Yes, good morning. I guess I'll make four basic points. Number one, there was no error by the trial court in applying at-issue waiver in this very unique circumstance. Number two, the court properly found that the common interest doctrine did not apply to the withheld communications between the two plaintiffs. Three, the plaintiff did not meet their burden of demonstrating that the attorney-client privilege applied to the communications between the plaintiff and the CP and the accountants. Those are the three aspects of the discovery order. And I'd also add, plaintiff has not challenged the dismissal, and that if any aspect of this order is affirmed, that dismissal should stand. And then finally, plaintiff didn't mention this morning, but it's in his brief about the sanction request. There was no abuse of discretion.
Why does that make sense? I mean, if we find that all the documents should have been protected except for one, we still have the dismissal. Why is that what Patel versus Martin says?
Well, I guess I would say this, Your Honor, having that Martin versus Patel case anticipates, rejected the present execution so we wouldn't have piecemeal appeals. And so it did talk about this option of taking in a contempt and a dismissal, but you have to live with the ramifications of that. And if it was willfully refused to turn over documents that should have, despite the court order, I don't see why they should get a second shake of it. So that's the basis for the position that if any aspect of this order is affirmed, the dismissal should stand. Then also they didn't brief any challenge to the dismissal.
What's our standard of review of the dismissal?
Excuse me, I'm sorry.
What is our standard of review of the dismissal?
They didn't raise it, so they didn't challenge the merits of the dismissal.
But what do you say? Do we review for an abuse of discretion?
Miscarriage of justice, clear error of law, and yeah, abuse of discretion. It would be discretionary. The judge is issuing a sanction.
If we were to disagree with any portion of the judge's reasoning, why wouldn't we then permit the judge to re-exercise their discretion?
I think, I'm sorry. I do understand your position, and I think that is a consideration I think is fair for you to consider. But I'd ask you to consider that before you found the judge abused your discretion for that dismissal, whether or not it should still stand given that whatever of the order remains. So as you evaluate her discretion, I think you have to pause and see whether the dismissal should still stand. I understand that an option is to send it back for the judge to look at it all if that was the case, but I don't think there's any error in this order.
Well, you would agree that dismissal would not be the appropriate response if the underlying assertion of privilege was valid.
If the entirety of the order was wrong, that the judge was wrong in allowing any disclosure, I would agree with you.
Right. And I don't know what you mean by entirety, because there wasn't a document by document assessment made by the judge.
Well, we can
I don't see how we could possibly make an evaluation of any individual document.
Well, I guess I was grouping them in three components, right? You have the at issue waiver portion of her ruling. You have the ruling pertaining to the communications between the plaintiffs, and you have the group of communications between a plaintiff and the asserted accountants. So those are three parts.
Right. And how is it, this is going back to Judge Sullivan's question, how is it that if we determine that any one of those three parts was in error, how is it that we would not remand to the judge to evaluate what the appropriate response is in that circumstance, if any?
I guess my response is because of the other aspects of the order, which were the decision was made not to follow what was really the recommendation of the SJC and Patel to bring all the issues up at the end. But if you are going to stand by that order and it's upheld in any respect, they didn't abide by an order. They were required to turn over those records. They didn't. They suffered a dismissal. They shouldn't get a second shot. I understand your concern, Judge. If you look at it the entirety, you may want to remand it back to a judge to consider whether dismissal is still appropriate sanction, but that wasn't briefed, that wasn't argued on appeal, and it's waived. As to the at-issue waiver, I don't believe there's any more compelling set of facts than what is before this court for at-issue waiver based on the discovery rule. Darius and McCarthy, the SJC decisions, while they didn't recognize it in those particular case, specifically said that they concede that the discovery rule would apply in appropriate circumstances. And this is that case. You know, they filed this act.
Counsel, that makes a lot of sense, but it's not what the judge based it on. Didn't base it on the discovery, based it on the negligence claim. Are you just defending it on the discovery?
No, fair question, Your Honor. I'm looking at it, I guess, primarily that you as a reviewing court can affirm on any grounds that was before the trial court. And so that was the fundamental argument below. I'm not walking away from what you relied upon, and that's a Zabin type of analysis that where a client sues a former attorney for malpractice, there's a waiver of all communications in the underlying litigation. But primarily this at-issue waiver is the prototype poster child, if not for application in the discovery rule. They are asserting or seeking refuge in the discovery rule. They say that it wasn't until present counsel that they learned that they had any legal rights or claims. They waited till after Alan died. Alan is unable to defend himself. They are asserting transactions and events that go back 20 years. And during the course of that time, they consulted with 20 different attorneys. And they are essentially, it has injected their lack of knowledge into this case, and yet they want to hide behind and not allow discovery of communications with counsel, which is where you would go to get advice about your legal rights and or knowledge of harm.
Was there a motion to dismiss filed based on the statute of limitations?
A motion to dismiss was not filed.
I mean, when we read the complaint, on the face of the complaint, it clearly looked time barred. But then there was no motion to dismiss. Was there a subsequent motion based on just the statute of limitations?
Well, no, and then there's no dispute here, Your Honor. I mean, look, and in hindsight, a motion to dismiss could have been filed. It's a very lenient standard, as you know, and they just assert, as they are now, the discovery rule. They're not denying that they're relying on the discovery rule. And in your earlier question, there's answers to interrogatories. I don't have the particular numbers. There's 3 or 4 where they assert we didn't know until we discussed with counsel.
Yeah.
So whether or not there was a motion to dismiss filed, this issue was they were going to rely on the discovery rule, which requires some measure of discovery. So, you know, it was mention of Darius. The only reason the court didn't apply the at-issue waiver in the discovery rule there, which involved an untimely presentment, was that the information that was being sought was from current counsel, which wasn't during the statutory bar period. Here, we're not seeking communications with Mr. Fryer. We're seeking the consults that were obtained prior to July of 2013, which would be the statutory bar period, given that they filed in 2016. And so, like I said, I think McCarthy and the SJC in a footnote says, well, look, we're not saying that the at-issue waiver doctrine does not apply. We see it could apply in the discovery rule context, and this is the perfect case. So for those reasons, I think the at-issue waiver found by the judge was perfectly appropriate.
How are we to know which, from the log, which documents fall into the common interest category, which, do you see what I'm saying? Because the basis of the privilege on the log for everything is the same, just attorney-client. How are we to know which documents might be affected by which portions of the judge's analysis?
Well, that's what I think you look at the groupings, Judge. You look at you can look at those communications withheld that were just between the plaintiffs. That's where the common interest reliance by the plaintiff is on, as to those documents. And then you got the small amount of documents of the plaintiff sending materials to an accountant, which they didn't prove were privileged. And then you have the remainder, which would be communications with all counsel prior to July of 2013, dealing with the same subjects that are subject of this action. So that's one way to look at the log. The log is difficult, and it does raise the issue of, the adequacy. The plaintiff bears the burden of demonstrating privilege, and you just can't submit a very deficient log, which made part of this issue difficult.
But if the judge determines that the log was sufficient, what is our standard of review?
Well, I don't know if she
determination.
Well, I think it's an issue of law, the adequacy of a log. I guess I bring it up in the context, for instance, of the, for example, the communications with the accountants. There was, you just can't rely on the assertion by counsel, oh, there are accountants that was done for the attorney. You need an affidavit. You need some kind of competent evidence to say that it was in furtherance and necessary for legal advice, and that's not there. That's why a bare bones privilege log is not sufficient, and that's consistent with the judge's finding that the communications with the accountants were not protected. So the second batch of documents mentioned were the communications between the two plaintiffs. They were 19 emails that
Actually,
were.
Before you go there, I just have one concern about Darius. In Darius at page 283, the SJC said courts that have found ad issue waivers have honored this principle by carefully crafting their orders so as to limit the permissible discovery to what is truly at issue. Is the order we have here similarly is it sufficiently limited or crafted? It just orders the production of these documents no matter what's in them.
Right. I think under a Zabin analysis of at issue waiver, where all communications with prior counsel during the time of the alleged negligence would be a one basis. But as to answer the question, as far as knowledge goes, I don't know how else you could deal with it, but to say, look at only that aspects dealing with knowledge should be disclosed. But that is a very difficult issue because that could be in the eye of the beholder, and leaving it to the counsel to provide the log to say, well, that doesn't deal with knowledge, it deals with something else. So in this instance, when it's a discovery rule dealing with knowledge, I don't think there's a way to limit it. Once that material
camera review.
It could have, that's a possibility for the judge. That was raised. It wasn't pursued by the plaintiff, Your Honor. It wasn't pursued. They took the position in this case as they are now. It's all or nothing. There's no such thing as a discovery at issue waiver. They never said to the judge, we need it to be limited. So, there's one aspect, they've waived that argument. The other aspect is, they have a remedy if that material was produced and it doesn't deal with knowledge, then they can file a motion to eliminate and it's not used. But I think the issue is waived. And I think because it deals with knowledge, the full disclosure of that information is permissible and not overly broad. As to the common interest doctrine, these communications between the two plaintiffs are clearly a waiver of the privilege, as noted by Judge Ditkoff. There's just no protection. You don't have the common interest doctrine apply. You have to have a common legal interest. That wasn't demonstrated. And both parties have to be represented, and it's undisputed that Catherine Turner had no representation during that time. And the reason the SJC in Hanover adopted the position that both parties in a common interest situation have to be represented is because we're trying to further legal advice. If there's no lawyer involved, there's no furtherance of legal advice. So those was a clearly required to be disclosed. I'd mentioned one case real briefly, the Cavalo case. I didn't, it was something I saw in preparing for today at 153 F sup second 52, a Judge Saris decision. There, the parents and their counsel met with their children about a common legal interest, but because the children didn't have separate counsel, the common interest didn't apply. And I just thought it was pretty pertinent here. Susan Brauner talking to her sister, if it in fact included attorney-client communication, which isn't even clear, and I would submit the plaintiff didn't bear their burden on that, it was a waiver.
All right, let me see, your time has expired. Let me see if there are any other questions from the panel. So we'll have to leave it there. I want to thank you both for your arguments in this case. It's a very interesting case, and your arguments have really aided the panel. So with that, we thank you, and the case is submitted.